My Lords, the next case, just very briefly, is HXA and Surrey County Council, tab 11 of the main authorities bundle, page 463 of that bundle. And it's 2024 One Weekly Law Reports 335.
Yes, and my thanks for the latest version of that, which arrived over lunch. Thank you very much.
In fact, my learned friend solicitors, they have to be.
What page are we on?
Page 463.
Thank you.
My Lords, this was another case where there was an attempt to sue a local authority for not removing children into, or taking children into care. In this case, to protect them from abuse by members of their own families. There were two cases alleged. In one, the claimant in the first case had never been removed from her home or made subject to a care order, but she alleged that the defendant had assumed responsibility to protect her because following a child protection investigation, the defendant had resolved to carry out a full assessment under Section 47 of the Children Act 1989 with a view to bringing care proceedings under Section 31 of that Act, but failed to do so. And on another occasion, the local authority had resolved to do what was called keeping safe work with her, but had failed to do so. And in the other case, the claimant had, in fact, she alleged an assumption of responsibility because she had, in fact, been taken into care a couple of times on a temporary basis and on a voluntary basis under Section 20 of the Children Act 1989. And she alleged that by reason of that fact, the local authority had assumed a duty to fully investigate her situation and keep her away from her birth family. Both cases had been dismissed, struck out by masters, and then upheld by the High Court judge. This court had reinstated them on the basis that they were arguable. A different Lord Justice Baker gave the judgment in that. And then the Supreme Court overturned the Court of Appeal and held the cases had been rightly struck out in the first place and that the facts had not given rise to a duty of care. And it suffices for my purposes in any event if I go to page 486 of the bundle. At paragraph 87, and this judgment was given by Lord Burrows and Lord Stevens jointly. Their Lordship said at paragraph 87, it is clear that a local authority has relevant statutory duties and powers, for example, the 1989 Act. It has also established laws laid down in Ex Minors in Bedfordshire County Council that in respect of such duties and powers, there is no cause of action for the tort of breach of statutory duty, even if this breach of statutory duty is a negligent breach. That does not mean that the common law tort of negligence has been excluded by statute. The statute in that respect is neutral, but what it does mean, as emphasised in N and Poole, is that the courts must decide whether there is a duty of care at common law by applying to the public authority the same principles that would be applied if the public authority had been a private individual. See also generally the illuminating articles by Bowman and Bailey, Negligence in the Realms of Public Law, a Positive Obligation to Rescue. It further means that one has to be very careful not to slide back to resting the duty of care and breach at common law on the mere fact that the public authority had statutory duties towards and powers in respect of the claimant. In our view, the submissions made by Ms Gumble KC on behalf of HXA and YXA fell into this trap. That is, she sometimes relied on there being a statutory duty on the local authority to safeguard children in need as the very reason why there must be a duty of care owed to such children. As we have just indicated, what is required, which the courts, perhaps unhelpfully, have sometimes referred to as the something more or something else, is that there would have been a duty of care because, for example, there is an assumption of responsibility had the public authority been a private individual. This is not to deny that, assuming there would otherwise be a common law duty of care, a particular statute may expressly or impliedly exclude that duty of care.
It may be that I've just missed it in what you took us to this morning, but is there a definitive or authoritative exposition in the authorities of when someone will be held to have assumed responsibility in these sort of circumstances?
Well, Michael, I submit,
That's the best.
is the best, and the closest on the facts that we've got to this case, I submit. Sherritt is another example which went the other way.
Yes, and on the facts, yes.
Yes.
I'm just wondering whether there's an authoritative statement that...
Michael is the most authoritative one gets, because in those passages I took my lordships to, Lord Toulson sets out what the nature of the Headley Burn duty is. There's that passage where he refers to traditional situations such as fiduciary duties and people in doctor-patient relationships and so forth. And then he also says in Headley Burns, another example, if there's representation and reliance. And in Michael, they were applying that latter type, questioning whether anything that the police officer or the police operator had said in the call had made any sort of implicit promise to the...
It's just for my part, speaking in terms of myself, Headley Burn is, as everybody knows, is a pure economic case,
Yes.
loss case, and it's directed to that. And so the language about being akin to contract is easy to understand. It's not so easy to just translate that
No,
into cases such as the present, where what we're dealing with is physical damage.
it's not. But Michael's, and we see it in Tyndall as well, where the Supreme Court refer back to Michael. What one looks for in this type of case is some sort of specific promise or assurance or undertaking that the defendant will do something that the claimant then relies on.
Not necessarily.
Not necessarily reliance in some cases, such as the children's one, as I'll come on to in
It needs, according to Tyndall, it needs to be something which creates a foreseeable risk of damage.
Well, no, I think in Tyndall it's answering a slightly different question, because the first issue is this an omissions case or a making things worse case?
Yeah.
And then if it's an omissions case, does one of the exceptions apply? And one of the exceptions is assumption of responsibility, as the Supreme Court have analysed it.
I was thinking in terms of two particular paragraphs. One is 56, which you'll certainly come to.
Yes.
Just if I can just flag it now, where they say that what some people have called Tafaris 2 is simply a manifestation of the general principles. And then 67, where they say, I got the question nearly right, but then explain the question that I should have asked.
Sorry, could you just repeat that?
Paragraph 67 of Tyndall in the Supreme Court, where they say I came close to getting it right, but didn't quite.
But you managed to get the right answer nonetheless.
I got the right answer. Yeah.
For the wrong reasons.
But by the end of this hearing, I would like to understand better than I do at the moment how assumption of responsibility works.
Yes.
In a case such as this.
Yes. It may be I need to think about that and come back to some of those passages in Michael. But on that point that you're touching on, they were specifically talking about Tafaris 2 being an example of making things worse. Because on Tafaris 2, you've prevented someone else from helping, essentially, or interfered with someone else that's in a way that stopped them from helping. So actually, conceptually, what you've done, if you've met that test, is you've made things worse. Whereas assumptions of responsibility may arise where you haven't actually made things worse. It is a pure omissions case, as in Michael. But by reason of either some relationship you have with the claimant, such as teacher, child, doctor, patient, you have a duty to protect, or you have, on the specific facts, assumed a duty to protect, which the Supreme Court in Tyndall say relates to making a promise, brackets, they say, undertaking or assurance, that you will do something on which the claimant then relies. And I accept there are exceptions to reliance, as the Supreme Court note in Tyndall, and HXA is one of them, because where you've got children who obviously aren't making any decisions based on what the local authority is doing, you can't say in any meaningful sense that they're relying on the local authority, and that's not in itself a reason why there's not a duty.
Thank you.
If you go beyond the children type of case, is reliance on, as it were, the relationship, protection, whatever, is not a necessary part of it?
What they say is in some cases it's not a necessary part. What I would submit is in a case like this, actually it is, because the point about the children's cases is the children aren't in a position to do anything to protect themselves. Obviously, in cases like this where reliance was applied as part of the test, such as in Michael and in Tyndall, people do have other opportunities to protect themselves. There's a difference with children. Now, maybe we should look at the passages in HXA which deal with that. But if I could just first of all, before I get there, just point out paragraph 91 of HXA, because it is a useful statement on assumption of responsibility. Paragraph 91, their lordships said, it's very common for the language of assumption of responsibility to be used at a high level of generality. However, it helps to sharpen up the analysis, always to ask, what is it being alleged that the defendant has assumed responsibility to use reasonable care to do? And then he said, although Ms. Gumble framed an assumption of responsibility in several different ways, in essence, she needs to satisfy the court that there was arguably an assumption of responsibility to use reasonable care to protect HXA and or YXA from the abuse that the local authority was aware of or ought to have known about. In this case, as I understand it, it's been said there was an assumption of responsibility to warn the claimant or in some other ways protect her from the harm. And in this case, the lordships found there wasn't assumption of responsibility at paragraph 93. They said in relation to HXA's claim, we have set out the particulars, and HXA alleges that an assumption of responsibility flows from the facts in those paragraphs. Paragraph 14 commences with the allegation that there was a child protection investigation after the defendant received a referral alleging that HXA's mother had assaulted HXA. Paragraph 14L also alleges that the defendant resolved to undertake a full assessment but did not do so. In relation to the assault, there were no particulars as to whether, and if so, what degree of violence was involved. We assume and proceed on the basis it was a serious assault. We also assume and proceed on the basis that the investigation which was carried out and the full assessment which was to be carried out was an investigation and assessment under section 47 of the Act. However, the nature of the statutory functions relied on itself does not entail the local authority assuming responsibility towards HXA to perform the investigation with reasonable care. Furthermore, it is clear from paragraph 81 of N and Poole that a local authority investigating HXA's position does not involve the provision of a service to HXA. Rather, the investigation is to enable the local authority to decide whether to bring care proceedings, which investigation would have involved determining the ability of HXA's mother and partner to keep HXA safe. In addition, no facts are alleged in the particulars of claim from which it can be inferred that HXA had entrusted her safety to the local authority or that the local authority had accepted that responsibility. And the parallel here, of course, is with the police. The police are performing a public law, common law, public law duty. But the question is, in relation to assumption of responsibility, is there something more which suggests that they've assumed a responsibility in private law to this particular individual. There's a footnote on reliance, paragraph 108, page 492.
492 electronic.
494 electronic.
And paragraph 108, did you say?
Yes.
Okay.
It says in the last two paragraphs, we've discussed situations in which there may be an assumption of responsibility. And they were describing things like taking the child into care or taking the child on a drive, for instance, keeping it safe. In the last two paragraphs, we've discussed situations in which there may be an assumption of responsibility and hence a duty of care owed by a local authority to protect a child from harm. That discussion suggests that it appears not to be a necessary feature of an assumption of responsibility in this area that there is reliance in any sense by the claimant. For instance, in a case like YXA, where one has a vulnerable young child with learning difficulties, it would be inappropriate to insist on specific reliance by the child in order to find that there was an assumption of responsibility triggering a duty of care during the respite period. So we can see when it's not required.
Yes, perhaps the key words are in this area.
Yes.
The breadth of those words may be subject of debate.
Yes, well, in this, I would submit he's in this context clearly speaking about children in the child context.
You're right.
That's all I wanted to say about HXA before I turn to Tyndall. And can I turn first of all to the Court of Appeal's judgment in Tyndall, because I submit that the Court of Appeal's summary of the law, actually subject to the addition of the Tafaris II principle as developed by the Supreme Court, remains good. And certainly the Supreme Court didn't say anything to disapprove it. My lords will be familiar with Tyndall, I anticipate. The facts being that the police had attended a road traffic accident involving an accident by Mr. Kendall, who had skidded on ice. Had the police not attended, Mr. Kendall's intention would have been to flag down traffic to warn oncoming traffic himself of the presence of the ice hazard. In fact, the police did attend, and Mr. Kendall went off to hospital in an ambulance, not having communicated anything about his intentions to the police. Half an hour after he left, and after the police had left the scene without taking adequate steps to make it safe, there was a fatal accident on the same spot of ice in which Mr. Tyndall was very tragically killed, as was the driver of the other vehicle. And Mr. Tyndall's estate sued the police on the basis that they had owed him a duty to make the road safe or provide some warning of its dangers to traffic that came after Mr. Kendall had left. The case, the police applied to strike the case out. The master initially declined to strike it out on the basis that she thought this was a developing area of law which ought to go to trial. The Court of Appeal, my Lord Justice Stuart-Smith, giving the principal judgment, overturned that and held that the case should be struck out because the police had not owed any relevant duty of care. The case then went to the Supreme Court, where the Supreme Court upheld the striking out of the case, albeit for slightly different reasons on one of the main points, but I will look at that in more detail. But in the meantime, in relation to the Court of Appeal's judgment, which is at tab 10 of the bundle, page 458. 444 is where it starts, but could I take the court to 458, to my Lord Justice Stuart-Smith's judgment, where he, having reviewed various authorities, sets out a summary of the law. And at paragraph 54, he said, in my judgment, this statement of principle applies to the police as to other authorities. However, when considering whether the police are to be taken to having assumed responsibility to an individual member of the public, so as to give rise to a duty to exercise reasonable care to protect them from harm, I must apply the principles derived from the decisions of high authority to which I have referred. In particular, 1, where a statutory authority, including the police, is entrusted with a mere power, it cannot generally be made liable for any damage sustained by a member of the public by reason of a failure to exercise that power. In general, the duty of a public authority is to avoid causing damage, not to prevent future damage due to causes for which they are not responsible. See East Suffolk and Stoven. 2, it follows that the public authority will not generally be held liable where it has intervened but has done so ineffectually, so that it has failed to confer a benefit that would have resulted if it had acted competently. See Capitals and Counties, Gorringe and Robinson. 3, Principle 2 applies even where it may be said that the public authority's intervention involves it taking control of operations. See East Suffolk, Capital and Counties. 4, knowledge of a danger which the public authority has power to address is not sufficient to give rise to a duty of care to address it effectually or to prevent harm arising from that danger. See Stoven. 5, mere arrival of a public authority upon or presence at a scene of potential danger is not sufficient to find a duty of care, even if members of the public might have an expectation that the public authority will intervene to tackle the potential danger. See Capital and Counties and Sandhar. 6, the fact that the public authority has intervened in the past in a manner that would confer a benefit on members of the public is not in itself sufficient to give rise to a duty of care, again in the same way or at all. See Gorringe. And one might also add there Mitchell's an example of that. 7, in cases involving the police, the courts have consistently drawn the distinction between merely acting ineffectually, e.g. Ansell, Alexandru, and making matters worse, e.g. Rigby, Knightley and Robinson. 8, the circumstances in which the police will be held to have assumed responsibility to an individual member of the public to protect them from harm are limited. It is not sufficient that the police are specifically alerted and respond to the risk of damage to identified property, Alexandru, or injury to members of the public at large, Ansell, or to an individual, Michael. 9, in determining whether a public authority owes a private law duty to an individual, it is material to ask whether the relationship between the authority and the individual is any different from the relationship between the authority and other members of the same class of the individual. See Gorringe, Per Lord Scott. And I should have said that in relation to a law, in relation to assumption of responsibility and principles, this is high authority in relation to it. I'm sorry for the discourtesy and not having mentioned it. I was planning to go there. Every one of those principles, I submit, remains the law and is well grounded in the authority that is cited for it. Turning then to Tyndall in the Supreme Court, which is at tab 12. Page 493, paper bundle 495, electronic. The Supreme Court started with the paragraph 1 of the introduction that has long been recognised that the tort of negligence draws a fundamental distinction between acts and omissions, or in the more illuminating language adopted in recent years, between making matters worse or harming and failing to confer a benefit or to protect from harm. As a general rule, a person has no common law duty to protect another person from harm or to take care to do so. Liability can arise only if a person acts in a way which makes another worse off as a result. In recent years, this distinction has taken on added significance because it is now firmly established or re-established that the liability of public authorities in the tort of negligence to pay compensation is governed by the same principles that apply to private individuals. Many public authorities, notably protective and rescue services such as the police force and fire brigade, have statutory powers and duties to protect the public from harm, but failure to do so, however blameworthy, does not make the authority liable in the tort of negligence to pay compensation for an injured person unless applying the same principles a private individual would have been so liable. That means to recover such compensation, a claimant generally needs to show that the public authority did not just fail to protect the claimant from harm, but actually caused harm to the claimant. Their Lordships then set out how the various facts of this particular case, and at paragraph 20 on page 501, they said that there could be no doubt on the facts that the failure of the police officers to take steps to protect road users from the danger posed by the ice hazard to which the officers had been alerted was a serious dereliction of their public duty owed to society at large. But as noted at the start of this judgment, it does not follow that they were in breach of a duty of care in the tort of negligence owed to particular individuals. And then they set out the citation from Michael I cited earlier. And at paragraph 21, they said this basic principle is not in dispute on this appeal, nor are the ordinary principles of the common law, as referred to by Lord Toulson and Michael, and in particular, the fundamental distinction between making matters worse and failing to confer a benefit. And then at page 508, paragraphs 42 and 43, their Lordships again cited what the general rule with its exceptions. At paragraph 34, Lord Reid cited as a helpful summary of exceptions to the general rule that there is no duty of care to protect from harm the opening sentence of Stelios Topharos and Sandy Steele's article. And they said at 43 that this summary has been cited again by this court in Enham Pool HXA and by the Privy Council in Great Lakes Reinsurance. And although this summary should clearly not be read as if it were a statute anymore, should any judicial statements, it is a useful starting point for analysis. And at paragraph 44, the Lordships, having cited various cases, including capital and counties, Ansell and McDermott, Gorringe, set out summaries which they derived, principles which they derived from them. Having examined some of the main cases, we can summarise the central principles to be derived from them as follows. There's a fundamental distinction drawn in all the above cases between making matters worse, where the finding of a duty of care is commonplace and straightforward, and failing to confer a benefit, including failing to protect a person from harm, where there is generally no duty of care owed. An example of the former, making matters worse, where there was held to be a duty of care owed by the police, is Robinson. As regards other emergency services, a more difficult example is the Hampshire case in Capital and Counties, turning off the sprinkler system. All the other cases mentioned fell on the other side of the line. A difficulty in drawing the distinction between making matters worse and failing to protect from harm is how to identify the baseline relative to which one judges whether the defendant has made matters worse. See Sandy Steele. The cases show that the relevant comparison is what would have happened if the defendant had done nothing at all and had never embarked on the activity which has given rise to the claim. The starting point is that the defendant generally owes no common law duty of care to undertake an activity which may result in benefit to another person. So it is only if carrying out the activity makes another person worse off than if the activity had not been undertaken that liability can arise. And that's why this is clearly an omissions case, because if the police had done nothing at all, Mrs. Woodcock would still have been in the same position that she was in. Another way of stating the general rule is to say that a person owes a duty to take care not to expose others to unreasonable and reasonably foreseeable risks of physical harm created by that person's own conduct. By contrast, no duty of care in general is owed to protect others from risks of physical harm which arise independently of the defendant's conduct, whether from natural causes, as in East Suffolk, or third parties, as in Michael and Ansell. Although not made out in any of the above 6 cases, there are exceptions to the general rule that there is no duty to protect a person from harm, for example, where the defendant has assumed a responsibility to do so or has control of a third party. Now, paragraph 45, a further point may usefully be made about the need to view the defendant's activity as a whole. This dispels the objection that it can be difficult or even arbitrary to distinguish between acts and omissions. Take, for example, what Lord Nichols said in Stoven and Wise, what he described as the classic illustration of failing to apply the handbrake when parking a car, with the result that the car rolls down a hill and causes damage to another vehicle. On one view, the damage in this example results from a mere omission. Any difficulty in explaining the common sense conclusion that the driver owes a duty of care disappears, however, when the focus is directed at the whole activity of driving, and the question is whether the damage would have occurred if the defendant had not engaged in that activity.
Stansby and Troman, though, or that example, is better explained, isn't it, by saying that although it was an omission in the sense of failing to apply the handbrake, it created a source of danger which was not otherwise there. So standard principles.
Yes,
your conduct gives rise to a risk that of injury that doesn't otherwise occur.
Yes, the decorator unlocked the door. The decorator in Stansby and Troman unlocked it.
Stansby and Haynes and Howard.
Haynes and Howard is the horse that kicks the boy.
Yeah, and they didn't put the brakes on.
They brought the danger along. That is not putting the brakes on. They brought the horse into an area where there were going to be people foreseeably about, where the horse might get foreseeably spooked.
But I'm sorry, if I'm not understanding this paragraph, because if you take your car out and stop on a hill and don't put the brake on,
yes,
it's not taking the car out that is the effective cause of the damage or the danger or anything like that.
No, it's not.
It is simply that you create a danger by not. So it's an explanation of why we no longer use the words acts and omissions. It's the risk you give rise to the risk of causing harm.
Yes. Yes.
I mean, far be it from me to agree with them, but it seems.
Well, they did say not to read it like it's a statute.
Yeah. But it seems, speaking entirely for myself, it seems to me that there's a much simpler rationalisation for paragraph 44.
Yes. That you.
But it would be churlish to complain.
No.
But also, if I can just add to what my lord has said, speaking in terms of the whole activity of driving, gives rise to the possibility of endless argument about when that whole activity began.
Yes.
It may have begun 300 miles away.
Yes.
But as my lord says, one would have thought a quicker and easier route was simply to say, what did you do wrong? Well, you parked the car in such a way that it rolled down the hill.
And the parking the car is obviously a positive act.
The manner of parking the car, doesn't it?
Yes.
You don't have to apply the handbrake if you turn the wheels into the curb and stick some handy pieces of wood underneath the wheels.
I suspect the issue has arisen because and I think my Lord Justice Stuart-Smith has just touched on this. What they're trying to do is help people identify and explain the difference between acts and omissions. And sometimes, of course, when one tries to do that, one opens up other questions Because the example itself they postulate is clearly right. There clearly would be a duty on the person. It's not an omissions case.
I'm sure you're right, but I envisage difficulty emerging out of this paragraph. And if I can just illustrate it for a second, because I think it may possibly be relevant to this case as well. We've got a case where we've heard argument, different constitutions of the court, where a person's car was driven into, and it's a credit hire case, of course, and the claimant claimed the cost of hiring the car on credit hire terms. And then it was discovered his car didn't have an MOT.
Yes.
So that raises in a very acute form, which at the moment I don't know the answer, so I can't give any indication, whether that should be characterised as the loss of something that, no loss because he wasn't allowed to drive his car on the road, or a loss because he had a car which he was driving on the road, but he was exposing himself to the possibility of prosecution all the time. And it's a causation question again. But it may be that the best way simply to regard 45 is yet another reason why we've abandoned the words acts and omissions.
Yes.
And that may be the simplest way to...
I certainly think that's what they were trying to drive at, because people tend to alight on a particular act or a particular omission, and then you lose the common sense position of it. I would respect Smith actually, although it is an interesting point, it doesn't actually arise in this case because there's nothing that the police activity in this case was everything I went through on the facts this morning, which you would expect in a police investigation of this type. But what they were not, what cannot be said is that if the police hadn't taken the steps they had, that this attack wouldn't have happened. And it's when you postulate that counterfactual in this case, the present appeal, one clearly sees it's an omissions case. Because if the police hadn't responded at all, if the police hadn't come out to see Mrs. Woodcock and given her advice on how she could protect herself, if the police hadn't responded to the 999 call, this attack would still have happened. And that leaves my learned friend resorting to the next part of Tyndall, which we're going to come on to, which is the Tafaris 2 exception, which, again, is a question of, can also be viewed as, did they create a danger? And that's where he then finds himself relying on the neighbour, who was not called to give any evidence. But if I could then maybe just progress on Tyndall. I'm not sure I'm going to be able to answer my lordship's question any more helpfully than that. Well,
I think your most potent reply so far, maybe it doesn't arise.
Yes. At paragraphs 49 on page 511, paragraph 49, we get to the making things worse Tafaris 2 example. In advancing this argument, the claimant's counsel relied both on the submission that the police made matters worse by creating an additional danger and on the second exception suggested by Tafaris and Steele. We see no substantive difference between these contentions. The exception relied on that A has done something which prevents another from protecting B from a source of danger is, on analysis, an instance of the general rule, a particular way of making matters worse by creating an additional danger. Indeed, Tafaris and Steele themselves recognise this when they return to this category of case later in their article in analysing when a duty of care is owed by the police. In that context, they describe the category as one where the police's involvement prevents alternative means of rescue, thus making the situation worse, our emphasis. This is not to deny that this particular form of making B worse off merits particular attention when one is considering liability for omissions because of its close factual connection to protecting a person from harm. And then they go on to say how no case had been cited by Tavares and Steele for the exception, and they trace it back through various academic writings. And they said at the bottom of 511, Duncan Fairgrieve, KC Honorary, who presented this part of the claimant's case, relied on this statement of the interference principle and submitted that it applies here. But again, they refer to the only case that's cited is, there's no direct case cited, but Kent and Griffiths was relied on by counsel. And the facts of Kent and Griffiths, my lords will recall, but the claimant had suffered an asthma attack at her home, paragraph 52. Her doctor attended and at 4:25 p.m. telephoned 999 and asked for an ambulance to take her to hospital immediately. When the ambulance failed to arrive, 2 further phone calls were made, and on each occasion the call handler said that the ambulance would be arriving within a few minutes. The ambulance did not arrive until 5:05 p.m. The delay resulted in the claimant suffering a respiratory arrest, which caused brain damage. The Court of Appeal decided that the ambulance service owed a duty of care to the claimant on the basis of assumption of responsibility arising from the emergency call. Lord Wolfe also accepted that if wrong information had not been given about the arrival of the ambulance, the claimant would have been driven to the hospital and arrived before her respiratory arrest. And then he said, in Michael, Lord Tolson explained and distinguished Kent and Griffiths on the ground that the call handler gave misleading assurances that an ambulance would be arriving shortly. In Darnley and Croydon Health Services, Lord Lloyd Jones, with whose judgment the rest of the Supreme Court agreed, also treated this as an alternative basis on which liability was founded in Kent and Griffiths. And then he sets out the facts of Darnley, which involved giving misleading information about the wait time to be triaged, leading a patient to leave and then suffer injury. And then, as I've mentioned, they refer to the fact OLL and say that it, in fact, should be analysed as an example of this situation. OLL being the case where the Coast Guard were alleged to have negligently misdirected other rescue services from a location where those who were stricken at sea might have been saved. But importantly, at paragraph 58, the court said, Lords Burrows and Leggett said, we also agree with the claimant that the detailed formulation of the interference principle by McBride and Bagshaw is correct. In particular, it is not enough to show that the defendant has acted in a way which had the effect of putting off or preventing someone else from helping the claimant. Rather, in line with the well-established approach to establishing any duty of care, for a duty of care to arise, it is necessary to show that the defendant knew or ought to have known, i.e. that it was reasonably foreseeable that its conduct would have this effect. So 2 parts to it. Firstly, that the defendant has acted in a way which puts someone off or prevented someone else from helping. And secondly, that the defendant knew or ought to have known his conduct would have that effect. And then paragraph 59 on the facts that it was accepted in that case, the claimant would need to show that the police knew or ought to reasonably have known that their conduct had the effect of putting off or preventing Mr. Kendall from warning other motorists of the ice hazard. And then in that case, and this comes to a point raised by my Lord Justice Stuart-Smith this morning about where the relevance of this comes in with causation and so forth. But this is at the first stage of duty. They said that we accept, this is paragraph 60, on the agreed and alleged facts that the attendance of the police at the scene of Mr. Kendall's accident caused Mr. Kendall to desist from attempts he would otherwise have made to alert other motorists to the ice on the road. It is not fatal to the claimant's case on causation that nothing was specifically said or done by a police officer to encourage or direct Mr. Kendall to stop his attempts to warn other motorists in leaving an ambulance. It is enough to establish causation that the attendance of the police at the scene had this effect. Nor was there anything untoward in Mr. Kendall's decision to leave. Someone in his position would naturally expect that once the police had arrived and he had told them about the ice, they would take charge of the situation and alert other road users to the dangers. It is also not an answer to the claimant's case to emphasise, as counsel for the defendant did, that nothing done by the police before Mr. Kendall left in the ambulance, or which may have contributed to his decision to leave, could reasonably have been described as negligent. To give rise to a duty of care, it would be sufficient that the activity of the police as a whole created a danger, i.e. that the activity of the police as a whole created an unreasonable and reasonably foreseeable risk of harm to the victim. Breach of such a duty would be established by a failure to take reasonable steps to remove the risk. Paragraph 62, where the claimant's case breaks down, however, is in relation to what the police knew or ought to have known about Mr. Kendall's warning efforts. There is no pleaded allegation that the police were aware that before calling 101, Mr. Kendall had been attempting to warn other motorists of the ice hazard, nor is it alleged that Mr. Kendall said anything to the call handler or to any of the police officers who attended the scene of his accident to suggest that he had any intention of making sense, nor are any other facts alleged from which an intention could reasonably have been inferred. Close examination of all the available evidence also reveals no basis for an inference. The focus of the claimant's case has been on Mr. Kendall's evidence about what he says he would have done had the police not arrived at the scene, but that is only part of the necessary inquiry. What is also critical is that the police knew or ought to have known about the role of Mr. Kendall and what he would have done but for their arrival. As far as the police were concerned, Mr. Kendall was someone who'd been injured in an accident and no more than that. He was a victim, not a rescuer. So two critical inquiries for this exception. What would the and I should remind the court this was a strikeout application and summary judgment application in Tyndall, whereas we've had a trial in this case. But two critical facts needed to be established. One was what Mr. Kendall would have done. Was he put off by the police? And then the ground on which Mrs. Tyndall's claim foundered that the police knew or ought to have known of that intention. And I do submit that both are absent in this case. It's fair to say when I took the court to the pleadings earlier, I did miss taking the court to the fact that there was an allegation of breach. If I could just briefly leave Tyndall and go back to the pleadings in the core bundle, the appeal core bundle at page 193. I took the court earlier to paragraphs 22, where the conversation with the neighbour was set out.
I apologise. What page number?
Page 193, in the allegations of breach. (193) in red at item C on page 193.
I'm not finding this page. This is the core bundle.
Yes. The core appeal bundle.
Yeah.
Page 193.
Right, I see. Yes. Sorry, I was looking at the electronic numbering. No,
Thank you for that.
still wrong. Which paragraph?
It's paragraph C, but it's in a lengthy, it's in paragraph, there are many allegations of negligence. It starts at paragraph 27.
No, I'm sorry, I'm just not finding it.
Would it help if I read out what it said?
Could you please? Yes, I'm sorry.
It said, failed to advise the said neighbour that there would be a delay in the defendant's officers arriving on the scene and that they would not be contacting the claimant prior to their arrival to warn her of the danger. It is averred that had the neighbour been informed of this, the neighbour would have been able to warn the claimant herself, but relying on the defendant did not do so.
Thank you, I've found it. Yeah.
And I drew attention earlier to the fact that none of this was pleaded in relation to duty. But what you will not find anywhere in the pleading is an allegation that the police knew or ought to have known of any intention of that nature on behalf of the neighbour, nor were the police cross-examined on the basis that they knew or ought to have known of any such intention. Nor, as I submitted earlier, was the neighbour even called by the claimant to make good that allegation. And in fact, as we looked at earlier, what the police were told by the neighbour was that really she didn't want to get involved. So we do submit in relation to the Tyndall to Faris 2 exception is of no assistance to my learned friend in this case.
Just before we leave the pleading, it's a tiny point, but I just wanted to confirm the pleading is in terms of the neighbour would have been able to warn the claimant himself. In fact, the neighbour's female, isn't she?
Yes.
Yeah, sure. Thank you.
If I could then just, sorry for that diversion, but I wanted to make sure I hadn't in any way inadvertently misled the court earlier. Go back to Tyndall. Which was back in the main authorities bundle. And
Page?
just, sorry, I've just...
We were at page 517 in the electronic bundle.
Thank you very much. Yes.
I'm just
Where the
showing
paragraph
off the
62.
now have it.
Yes. Thank you. If I could then, sorry, move to paragraph 73, because the Lordships then considered, after having considered a similar allegation which wasn't pleaded or evidenced about the fire service, they moved on to assumption of responsibility. So paragraph 75 on page 521 electronic, which is 519 of the paper bundle. Now, paragraph 75, they said, while somewhat elusive and possibly having different requirements in different contexts, e.g. pure economic loss and misrepresentations, for present purposes, an assumption of responsibility involves the idea that a person may, by words or conduct, expressly or impliedly, promise or undertake or give an assurance to take care to protect another person from harm. In some situations, but not all, for an exception, see HXA and Surrey. Para 108, which we looked at earlier, it is also a necessary element that the claimant has relied on this promise. An example is provided by Kent and Griffiths, where the call handler for the London Ambulance Service gave assurances that an ambulance would attend with reasonable speed. By contrast, in Michael, it was found that the police call handler had made no such promise. The principle of assumption of responsibility can be evoked to explain the duty of care that arises when a person voluntarily accepts a specific role or enters into a specific relationship with another person, which carries with it recognised responsibilities to protect the other person's welfare. A classic example is the relationship between a professional person and his or her client or patient. The basic stumbling block for any argument based on assumption of responsibility in this case is the complete absence of any communication or interaction between the police officers who attended the scene of Mr. Kendall's accident, and Mr. Tyndall, police officers did not say or do anything of which Mr. Tyndall or other motorists who drove along the relevant section of the road after the police had left were aware or on which they could have relied. And then at paragraphs 84, they rejected an argument, or they pointed out that counsel had rightly issued reliance on an argument that the exercise of a power of control without an exercise of control is capable of giving rise to a duty. At times, they appeared to suggest that a duty of care could arise from the fact that the police took steps attending the scene with blue emergency lights flashing and putting up a sign to encourage motorists to slow down, which temporarily reduced the risk of another accident, but which were then terminated when the police left, taking the sign with them. Any such argument is untenable, as illustrated by cases such as East Suffolk, Ansell, Capital and Counties, and Gorringe, taking steps which are ineffectual, whether because they are inadequate to begin with or because the defendant does not persist in them, cannot give rise to a duty of care. And then in relation to status, they said the last head of liability suggested by Tavares and Steele is that A's status creates an obligation to protect B from danger. And in their article, Tavares and Steele developed an argument that the police have a special status derived from the fact that they are the primary body legally entitled to intervene and use force to protect citizens from criminal activity. They argued that this status and the corresponding dependence of members of the public on the police for their safety are enhanced by the fact that the victim cannot generally protect or reasonably be expected to protect herself against the threat of violence. They propose that the police should be held to a duty of care to a person who, as the police know or ought to know, is at a special risk of personal harm. Whatever merit this argument might otherwise have had, it is irreconcilable with the decision of this court in Michael. Tavares and Steele acknowledged this in their article and expressed the view that Michael should be overturned. We have not been invited on this appeal to consider departing from Michael, and given the weight of that authority and the further body of authority since founded on it, this would not have been a realistic argument to advance. I mention it because it's at least trailed my learned friend's skeleton in this case. My lords, against that background, can I turn briefly to the judgments, and very briefly, first of all, to the judgment of His Honour Judge Murdoch. That can be found at
143 in the electronic bundle.
Thank you.
Did anybody try to get a transcript of the judgment
Yes.
delivered?
Oh, of the judgment is delivered. Yes.
Because this looks like the judge's notes for
Yes.
him to speak to. But this
There's
is
been a problem with getting the transcripts, and it may well be, I don't know if it's an issue or not, but this was heard during COVID, when COVID was in full flow. And you may have noticed the trial was actually heard by video link.
Yes.
There have been, because we've also sought, because there's a dispute between junior counsel as to whether the claimant was offered a chance to give evidence on causation again at the end of the case, we've also sought a transcript of that. No transcript has been able to be located by the court, I'm told. But it is perhaps a feature to bear in mind in relation to the structure of the judgment, the circumstances in which it was being, the trial was being heard and the judgment delivered. But the key issues were His Honour Judge Murdoch, I submit, actually got things right. Or if one goes to page 154 of the bundle, he set out what he drew from Hill. He cited Hill, Robinson and Michael in the previous passages. And in relation to Michael, in relation to Hill, he said the police have a wide discretion as to how they address their statutory functions. Police officers may be liable in tort for their acts or commissions. Robinson confirms that the police would not normally be under a duty to protect from a danger they have not created. And Michael makes it clear that the police may owe such a duty if they assume a positive responsibility to safeguard the claimant under the Headley-Byrne principle. He said, in my judgment, the facts of this case, although different in detail to that in Michael, mirror the same issues raised. And I do submit he was actually right about that. He identified the correct authority. And he held that this was an omissions case and that on the facts, the police had not assumed a private law responsibility to the claimant. At the bottom of page 155, he reached those conclusions. And then if I could turn to the judgment of Mr. Justice Ritchie at page, which begins at page 62. Sorry, 52, page 52. And in broad terms, what I submit about this judgment is that where the judge has gone wrong is that he's failed to recognise that he's dealing with an omissions case. And allied to that, he has failed to appreciate the reorienteering of the law represented by Michael and Robinson away from public policy considerations to orthodox common law principles. And again, allied to that, he has failed to appreciate the full significance of the reasoning and the outcome in Michael and wrongly distinguished it. And on that point, if one goes to paragraph 30 of the judgment, which is on page 63 of the bundle, the judge, having considered Michael and its facts and some of its reasoning, said at paragraph 30, so the claimant's action in Michael failed. All the call handler had done was to take the potential victim's call and pass it on to her local police station. That was not sufficient to make out the special circumstances or assumed responsibility exceptions. And then this sentence, or this subclause, and in any event, it appears to me that the alleged breach by omission, if any, was a failure to get to the house in 14 minutes, which was a matter of consideration of whether that was possible in the light of the other policing duties carried out by the Cardiff Police that night. The facts are quite different from those in the appeal before me, which I shall set out from the judge's findings. So he seems to have thought Michael was partly decided as a breach issue. And then he was critical of the first instance judge in relation to the fact that he'd cited just the 3 cases and not necessarily in the right order. But at paragraph 32, he said, with the judge having given a summary of the law, the bit we've just looked at, he said, with due respect to the learned judge, that summary is barely sufficient analysis in relation to the 3 cases he referred to. He has also overlooked any analysis of the exceptional cases or special circumstances duty. He referred only to the Headley-Byrne exception. That case is the classic authority for a duty of care relating to negligent misrepresentation. It has been referred to in various civil action against the police as a foundation for a responsibility exception. The reasoning being that if the police have represented to the victim, they will keep her safe, and if the victim has relied on that promise and acted to her detriment, for instance by sending away her own private security guards, then the police have assumed a duty of care. In my judgment, whilst the set of facts, unlikely though they may be, may well fulfil the exception called assumption of responsibility, it's probably not the only trigger.
What case is that a reference to? Sending away bodyguards?
I'm not sure it is a reference. I think it's I'm not sure there is a case where the bodyguards were sent away.
No, I think it's given as an example by someone in the Supreme Court in one of the judgments.
That might
I
be
can't
it.
be aware, I'm afraid.
I'll try and find that. Paragraph 32, or one of my juniors might try and find it. And then this is where I submit the judge has been led into error, because he then at paragraphs 33 and 34 goes back to the pre-Robinson reasoning through Brooks and Smith. And one sees that he begins to highlight what he takes from those cases as a potential exception. At paragraph 33, for instance, he quotes from Lord Nichols in Brooks, who he says briefly mentioned the exceptional cases. Quotes, there may be exceptional cases where the circumstances compel the conclusion that the absence of a remedy sounding in damages would be an affront to the principles which underlie the common law. And then the decision in Hill would not stand in the way. And at paragraph 35, he similarly refers to a dictum from Lord Steyn about it being unnecessary in this case to try to imagine cases of outrageous negligence by the police, unprotected by specific torts which could fall beyond the reach of the Hill principle. It would be unwise to try to predict accurately what unusual cases could conceivably arise. I certainly do not say they could not arise, but such exceptional cases will have to be considered and determined if and when they occur. And then at paragraph 41, we get a summary of where his lordship got to. What he took from the earlier cases was that in Smith and Van Call, the House of Lords restated the general rule and acknowledged the existence of exceptions to the general rule that the police are not liable in civil law for failing to catch criminals or to prevent crime. The exceptions were categorised as 1, special circumstances, and or 2, exceptional cases, and or 3, the assumption of responsibility to protect. But the constituent elements of or triggers for the exceptions were not defined. And category 3 was not confined to the Headley-Byrne triggers. And what seems to have happened there, he seems to have missed the fact that the Supreme Court said that the exceptions to the omissions principle were the Tavares and Steele exceptions, albeit nothing in negligence, of course, is ever closed. But he seems to have thought there's an additional category of an exceptional case. He then, we respectfully submit, got distracted by cases such as in paragraph 45, ABC in St George's Hospital, case in a clinical negligence context about whether there was a duty owed by a doctor to advise the daughter of a patient about a genetic condition that her father had suffered. And he did acknowledge at paragraph 45 that that case is different because although the common law factors are the same, the public policy factors are quite different with the police. But later on, he did rely on it. And then at paragraph 47, he distinguished Tyndall at that stage in the Court of Appeal. He set out the passage I took the court to from my Lord Justice Stuart-Smith's summary of the law. But at paragraph 48, he dismissed it on the basis that Tyndall related to the actions of the police, which did not make matters worse, but likewise did not make matters safer. Those facts are different from the facts in the appeal before me. So he seems, that I submit respectfully goes to the core area where the judge has gone wrong, which is that he's failed to recognise he's dealing with an omissions case, just as Tyndall was. And then at paragraph 49, the judge sets out the principles that he derives from the various cases. One, that the general common law principles which apply to the imposition of a duty of care in any member of the public apply as normal to the police. Well, that's correct. Two, the police are under a general duty of care to their neighbours during the course of their operations in the Donoghue and Stevens sense, and so will be held liable for their actions which cause damage to persons who are property which is proximate to them and may reasonably foreseeably be damaged or injured by their careless actions, subject to the clear public policy considerations which may affect the extent of such a duty. That's correct. Three, whilst the police carry statutory and general duties to protect the public, these duties are matters for internal regulation and discipline, and if necessary for judicial review. The police owe no general civil liability duty of care to protect the public at large, and if so, if the police fail to find or catch criminals who then injure members of the public or damage property, the police are not liable, whether quiet insurers or otherwise, for the injury or damage caused by those third-party criminals. Public policy and the public purse does not support the police being held to account as the civil liability insurers of the public from criminality. The police are not responsible in civil law for the crimes of criminals. The latter are responsible for their own crimes. Criminal Injuries Compensation Scheme covers such cases. So whilst he's reached in that the right conclusion on what the general position of the police is, what one sees is that he's reasoned it from the old public policy grounds. And then key to his finding against the police on appeal is paragraph 49(4), where the learned judge with respect has introduced his own novelty to this area of the law, or perhaps more accurately seems to have brought something very like Lord Kerr's liability principle, which was rejected by the majority in Michael as being the operative one. And he says the exceptions to the general rule that the police are not liable and owe no duty of care for failing to act or failing to prevent harm caused by criminals are limited to cases where, one, the police have assumed a specific responsibility to protect a specific member of the public from attack by a specific person or persons, and then two, exceptional or special circumstances exist which create a duty to act to protect the victim, and or it would be an affront to justice if they were not held to account to the victim, and to engage a duty of care on the police to act to protect a member of the public. The courts will carry out a close analysis of the evidence relating to A, the foreseeability of harm and seriousness of the foreseeable harm to the specific member of the public, the suggested victim, and two, the reported or known actions and words of the specific alleged protagonist in relation to the feared or threatened harm, and C, the course of dealing between the potential victim and the police and the alleged protagonist, focusing on proximity, and D, the express or implied words or actions of the police in relation to protecting the victim from attack by the protagonist, and the reliance of the victim, of any, if any, on the police for protection as a result, and E, whether the public policy reasons for refusing to impose a duty of care outweigh the public policy in providing compensation for tortiously caused damage or injury. And then he says, in my judgment, only if factors A to C and E, and in some cases also D, are proven on the balance of probabilities by the claimant with sufficient weight and severity and immediacy, will the common law, combined with public policy, exceptionally permit the courts to rule a duty of care was owed. Paragraph 52 appears to bring Human Rights Act concepts into the analysis. Again, we would submit contrary to what the Supreme Court said in Michael, because he says the case law set out above shows that reports to the police that a current or ex-partner has threatened the victim with violence and that the threat is imminent are not sufficient to engage any civil liability on the police for failing to prevent an attack, which then incurs unless they satisfy the Human Rights Act criteria. Then paragraph 53, he relies on R and Dytham, which is the case where a police officer stood back and did nothing as somebody was murdered in front of him outside a club. And the police officer was convicted of misconduct in public office in the criminal courts. And he seems to have thought that was a case in which civil liability might have been imposed. But as we saw earlier, Lord Reid identified as that as...
Might have been imposed.
Yes. But as we saw earlier, Lord Reid drew a distinction between that case and the private law duty. And then, no doubt, because it was cited to him, he then put a particular weight on a case from 2011, pre the Michael and Robinson corrective, from the a strikeout application from the High Court in Northern Ireland, where the High Court judge refused to strike out a claim arising out of the Omagh atrocity on the basis that the police might have been able to prevent it. At paragraph 59, another case which he relied on was Sherratt, where he said King J upheld a recorder's decision that the police were liable for failing to protect a woman who was reported as suicidal by her mother, based on assumed responsibility through the words used by the police 999 operator to the mother on which she relied. The Headley burn factors were analysed, and King wrote the representations or assurances did not have to be given to the victim. All of that is true, but it is helpful to actually see the facts of Sherratt, which involved the police giving a very specific undertaking to turn up and do something.
And then Sherratt was a strikeout.
It was a preliminary issue.
Preliminary issue.
Preliminary issue. So. He then, at paragraph, if we can move on to paragraph 103, at page page 86, he then distinguished Michael. He said, as to comparable cases, I consider that this case is not the same as Michael. That was not a duty to warn case. It was a failure to protect by arresting the protagonist case. Secondly, this case is different from Smith and Van Cole, which were likewise failure to protect, not failure to warn cases.
Which paragraph are you in?
103.
Thank you.
Now, as I said earlier, in fairness to the judge, he wasn't referred to Mitchell, where he might more clearly have seen.
But at the moment, this is as much for Mr. Bowen as for you. I don't begin to understand the difference between a duty to warn case and a duty to protect case.
No, and we submit in our appeal there is no such difference. One is an example of the other. Both, as I said earlier, the classic omission is failing to shout a warning to the blind man who's about to walk off the cliff. And then at paragraph 105 onwards, he applies his 49.4 test. It looks at foreseeability in 105 and then goes on to focus on what reported actions and words were about the protagonist. So this is applying essentially Lord Kerr's exception. Then looks at paragraph 107 at the course of dealing between the potential victim, the police, and the alleged protagonist, focusing on proximity. And he says when considering proximity in this case, the key factors are the repeated failure of RG to comply with protective bail conditions and the substantially increased frequency of his attempts to get close to the claimant on the 17th and 18th of March, aligned with his threats to kill and rape. And to note at the end of paragraph 107, he pointed out, as I've been submitting, that the neighbour told the defendant she could not herself call the claimant and rightly did not want to go outside to tell her. And then at D, he looked at express and implied words or actions of the police.
Did Judge Murdoch make an express finding about that?
Sorry, could you repeat that?
Did the judge at first instance, Judge Murdoch, make a separate finding about
No,
that? We've got it in the transcript.
He simply recited the transcript as I recall. Okay. And I mean, as I said earlier, it's perhaps not surprising he didn't make an express finding on it since no evidence was called about it.
I'm sorry, my hearing is disabling me here. A finding on?
The last sentence of paragraph 107.
Yeah.
The neighbour told the defendant she could not herself call the claimant and rightly did not want to go outside to tell her.
Yeah. All right. No finding.
Mr. Warnock has reminded me, A, that the neighbour wasn't called, B, that they had the transcript, and C, in his submission, it's not surprising that a specific finding was not made.
Yeah, it's a question of inference by the judge. Anyway.
That goes back to what I asked this morning about the transcripts being treated as if they were evidence. Yep, thank you.
At paragraph 1.8, then he looked at the express words or actions of the police and put importance on the fact that the police had visited the claimant twice and took into account that the claimant had asked for protection on the evening of the 18th of March and that she was given comfort protection in a conversation with PC White and by PS Goosey in a car outside her house, albeit for an unknown period of time, depending on operational demands which might arise overnight. And he then took into account the detailed safety plans, as he called it, drawn up by the defendant, with the claimant being advised that night to conscript neighbours to look out for RG. And he drew from all of this that there was a very close tripartite nexus at the end of 108, in which the claimant was relying on the defendant's officer's advice and the safety plan. And then he said, in my judgment, there'd be little point in advising the claimant to ask neighbours to keep watch for RG and to tell the claimant or the police if the police were then going to keep any such reports secret from the claimant at the precise time when the claimant was due to leave the house to go to work. And we respectfully submit what he seems to be doing here is working back with hindsight from what happened and seeing the advice which the police had given, which had all been about how the claimant could protect herself. In fact, it did not involve any promise by the police, but he's worked back from hindsight with what's happened. And he's not asked himself the correct question, which is, had the police made a promise or an undertaking or given an assurance to do something? Keeping it secret, we would also submit as a rather pejorative way of looking at the facts in the case, in fairness to the officers.
Well, in addition to being pejorative, it might be said that it categorises an omission as a positive decision.
Yes.
You know, under no circumstances are we going to tell her this.
Yes, which is not what the evidence was at all.
No.
He then went on to consider public policy, and again, this we submit sits inconsistently with Michael, because whereas the Supreme Court in Michael had said that an exception to the common law should not be carved out in relation to domestic violence cases, and indeed, certainly we're not looking even in argument on one based on gender. The judge here says abused women need protection, and he needs to consider the public policy reasons in Hill in taking that into account. And at paragraph 110, he said the duty of care that he found would not undermine the police's operational decision-making or fetter the police in taking a robust approach to the modus operandi. I do not consider such a duty in circumstances will lead to a plethora of litigation which will restrict the availability of police for their operational duties. Well, in fact, again, insofar as it's relevant to take account of such matters at all, Lord Toulson in Michael expressly said the one thing one could foresee from imposing the duty that was being sought was a plethora of litigation and cost. And then, as I said, at paragraph 112, he draws, he considers that the case has similarities to the decision of the Belfast court in Rush. And then we do submit somewhat remarkably, says that the appeal also has similarities to Dytham, which my lords will recall was the case where an officer stood by and watched an officer had he been murdered and then drove off. And of course, we would remind the courts in defence of the officers in this case that they rushed to try and arrest Mr. Guzzle-Yart, regardless of their own safety.
Sorry, which paragraph is that?
Paragraph 112. Then at paragraph 113, he said, in addition, I consider the defendant's words and actions in the full circumstances set out above gave to the claimant having a reasonable expectation that the defendant would inform her that RG was loitering outside her house in circumstances where she was soon likely to leave her house and there would be to a 5 to 10 minute gap before the arrival of the police. The claimant was relying on the police to pass on the neighbour's message. Well, just on the facts, there was in fact no evidence given of any such reasonable expectation. And again, the judge is looking at a very specific outcome of what happened without asking himself, did the police promise this claimant in a way which takes them away from just performing their general public law duties as the police? Did the police promise this claimant that they were going to do something specific? Going back to what Lord Burroughs and Stevens said in HXXA, asking what is it been said that the police assumed responsibility to do, and how they said to have assumed it. And with respect, the safety plan, which gave the claimant advice as to how she could keep herself safe, did not involve the police promising to do anything beyond what they provide to anybody who's a victim of a crime. And then he also, to presumably to buttress the decision that there was an assumption of responsibility, brought public policy into that too. And I should say he referred to, there were similarities to Sherratt in relation to the duties on the police when given information about imminent danger and in relation to reliance. And we do submit it's interesting that he's focused on those parts of Sherratt, but he's missed the key fact of Sherratt, which was that the police promised to do something specific. And then he says in public policy, it would undermine the purpose of official or unofficial cocoons and of flagging victims' contact details, of safety plans and advice to lock doors and stay inside in a domestic abuse setting if the public were to know that the police had no duty to pass on urgent warnings. It would encourage to the victims of criminals subject to manhunts who lurk outside the victim's property. It would encourage stalkers and it would discourage good practice. My Lords, in doing that, I've sought to go through essentially what our grounds of appeal are, which I've set out in our skeleton from paragraphs 30 onwards, so they're all there in writing with the notes, and I'm not proposing to, unless your Lordships want me to, go over them again. But in broad terms, summary terms, in our submission, this was plainly a failure to confer a benefits case, or stroke, otherwise known as an omissions case. The gravamen of the complaint is that the police failed to protect the claimant from the criminal actions of a third party. Secondly,
I failed to protect the claimant by passing on the fact that he was standing outside.
Yes. None of the exceptions recognised in the recent run of Supreme Court decisions applied. In particular, this was not an assumption of responsibility case. An application of Michael, endorsed by the Supreme Court in Tyndall, makes that plain. The advice given by the police related to how the claimant could protect herself. It involved no promise that the police would pass on a warning received by a neighbour. It involved no promise that the police would do anything. Nor to deal with the respondent's notice. Is this an interference exception case to Paris 2? It's not even pleaded. There's no evidence from the neighbour that she would have done something had she known the police would not contact her. In fact, the transcript of the call we have goes the other way. She understandably and quite sensibly did not want to get involved. Nor did the police tell her that they intended to give a warning. So it's not apparent how the claimant could have advanced a case that she was relying on the police to give such a warning. All the police told her was that they would send someone round as soon as they could, which they did. Moreover, as I've said, no such case was ever put to the police officers, nor was it ever pleaded that they knew or ought to have known that the neighbour would otherwise get involved. And as I've said, the call would have given them the clear impression that she would not. In relation to the other exceptions, the police did not have control of the perpetrator, as in Michael. Similar to Michael in that respect too. They were actually trying to find him. And finally, the status of the police, the Supreme Court have confirmed, does not give rise to a duty as confirmed in Tyndall. Those are my submissions in relation to the duty of care, unless my lords have any particular question for me. And if not, I'll hand over to my learned friend, Mr. Holcroft, who'll deal with the breach and causation.
No, just whilst Mr. Holcroft is gathering his thoughts and his papers, we'll just rise for a couple of minutes just for stretch legs.
Holroyde available.
Sorry?
After 6 pages. Yeah. Yeah.
It's a single paragraph. No. He's wrong. Yeah, I've got hard copies of books out there. Mine's wrong. He wasn't having no heart.
Well done, walk.
We're streaming still.
Oh, are we? No. Oh, I'm sure they've switched it off.
Green means go.
Right.
How long you been? 15 minutes, half an hour?
Oh, right.
Well, depends if they're polite or just not.
Okay. Not 2 minutes.
Not 3 minutes.
when ready.
I know what you. Spare file. No, don't worry.
No, no.
What right is able?
Exploded.
It's all right, thanks, Joe. Yes, Mr. Woodcock.
My lord, I hope you're still where my learned leader left you, at page 89 and paragraph 115 of Mr. Justice Ritchie's judgment.
Thank you.
He deals with breach of duty in that single paragraph, and in doing so, he makes a number of fundamental mistakes. Firstly, having recognised that the burden of proving a breach was upon the claimant, which he does separately at page 72 and paragraph 51, and I don't imagine that's controversial. He wrongly approaches the evidence presented by the defendant. And he's conflated the roles of those who work within the force control room, which he's described as the telephone operatives, and the police officers on the ground who make the decisions about how to police. And where he says that the trial judge wrongly focused on the training and allocated responsibilities of the telephone operatives, that is because he has not understood the role of those operatives in allocating tasks to officers. Because the role of the telephone operatives is to assess the risk posed, and my lords will have seen throughout the bundle that immediate is the highest level of risk posed, prompt the next risk down. And in this instance, the telephone operatives had properly recognised the risk as an immediate risk, that being the highest category. That is the extent of their duties, training and responsibilities, because they then pass that information to the police officers who decide how to best meet that risk, exercising their reasonable skill and judgment. And again, this is a further difficulty in Mr. Justice Rich's judgment, in that he appears to have decided that by finding a duty, he's also found the breach.
Well, if by any of the permissible routes on the law as it now stands, the police were under a duty to pass on the message,
then that would be an absolute duty, if that were the duty.
or to take reasonable care, and there's no defence case that they weren't able to pass on the message, is there?
No, the defence case is, as Sergeant Randall put it, it was a matter of operational judgment. And as the trial judge found, he was told by no officer that they would have rung the claimant.
But that works if the duty is a generalised duty to protect. I can see how within that envelope, if I can call it that, you can say, well, it's an operative decision. It was either made in accordance with internal regulations or not, so far as that's relevant. But if the duty is more specific, which it could be, I'm not saying it is, but you can conceive of facts where if, for example, the police had assumed responsibility and said, you don't need to tell your neighbours your phone number, because if we get to hear that he's nearby, we will ring you straight away so you stay indoors. If you can conceive of a variation of those facts, which gives rise to an assumption of responsibility and could give rise to a duty to pass on a message. If the duty is as specific as that, there's no defence, is there?
If the duty is as specific as that, no.
Okay, thank you.
But then that would remove all decision making.
I do understand that there is more to this case than that, but I just wanted to be clear that, as so often happens, the scope of the duty may be absolutely critical.
Yes, my lord. But we say that in defining that scope, it's going to have to allow for some judgment on the ground by the officers tasked with investigating crime and arresting Mr. Guzzle.
Mm-hmm.
And on that, the evidence before the trial judge, and this is at page 152 in the core bundle.
152.
152. And happily, I think all of my page references will be right in hard or soft copy from this point. It's the centre of the page, the summary of Sergeant Randall's evidence. He says, in answer to the question as to why he did not call the claimant on his way to her home, he told me it was a judgment call. He had decided to deploy himself and his priority was to get to the property as fast as he could. That needs to be seen through the prism of the analysis of risk, which again, the evidence as the trial judge, Judge Murdoch, set it out at the bottom of 153, is that risk is dynamic. It is not a simple case of saying that risk increases outside a home. Victims are at risk from perpetrators, forcing entry and being assaulted by items within the home, commonly kitchen knives or tools. Most perpetrators do not want the spotlight of witnesses, so attacks on victims in broad daylight, outside and at a busy time of day are highly unusual. The reason that that mattered in this case is because the police evidence was that the best way of addressing this risk was to arrest the suspect as quickly as possible. And again, His Honour Judge Murdoch reflected that evidence at page 157.
Where on the page?
In the third large paragraph down underneath Sergeant Randall failed to contact Hutton Wall. It said that Sergeant Randall acted in a timely manner. He deployed as soon as it came in. He raced to the claimant's address, arriving within minutes. He used his judgment. No one knew that he was armed with a knife. It's the next sentence that I crave in A. I heard most of the police witnesses say that the most effective method to reduce risk is to remove its source and to arrest the perpetrator would achieve that aim. Sergeant Randall knew the perpetrator was outside her home, he knew where he was and could now be arrested. He wanted to get there as soon as he could to effect that plan. I find Sergeant Randall acted as many officers would have done and bears no responsibility for the events that established risk by him. So, my Lord, I say that's the trial judge recognising that the decision whether to make the telephone call or not is a judgment call to be assessed through the prism of reasonableness, and that he assessed Sergeant Randall's decision as a reasonable one on the basis of the evidence that had been provided. It appears from Mr. Justice Ritchie's findings on breach that he placed great weight on the previous interactions between the police and the claimant, and he finds that there was updates on at least 3 occasions. That is correct, but again, where Mr. Justice Ritchie fell into error is that the updates on those occasions were updates mandated by the national policy or the code of practice for updating of victims. That sets out certain types of information that must be provided to victims of crime within 5 working days. And if my Lords need to see that, it's at bundle page 163 of the supplementary bundle. And it includes matters such as a suspect has been arrested, a suspect is on bail, a suspect has been released.
That's different situations.
It doesn't include this situation. But my Lord, the reason that is important is because Mr. Justice Ritchie relied upon that policy and the fact of the calls to update in accordance with the policy as a finding underlying his finding that there had been a breach.
Is that the good practice guidance?
It's the good practice guidance, my Lord, yes. And why that is difficult is because Mr. Justice Ritchie specifically found, and this is within, it's actually paragraph 94 of his judgment, which is on page 84, but it needs to be seen in the context of him rehearsing the guidance at page 163. So at the bottom of page 83 of the core bundle, within paragraph 93, reference to the guidance. In particular, the victim should be promptly informed of the following: any arrest, release or otherwise of a suspect, bail and conditions applied whether by the police or a court, conditions attached to a restraining order, any variations to a restraining order, release from prison, and any other conditions attached. So a clear and prescriptive list. Mr. Justice Ritchie then went on at paragraph 94 to say it is correct to observe that this list does not include advice for the police to inform a domestic abuse victim of a 999 report by a neighbour that the abusive ex-partner who had made threats to kill and whom the police had decided to arrest was loitering outside her house at just about the time she was due to leave for work with her children in the morning. On the other hand, looking at the matters which the police are required to inform domestic abuse victims about, such urgent information would fall logically within that list. Well, there was no evidence to support that apparent logic. And it is right to say that the officers acted in accordance with the national and the local guidance in all that they did. And that even the updated guidance does not contain matters contemplated by Mr. Justice Ritchie. So,
well, is the distinction you're drawing this? The guidance refers to certain steps being taken on the occurrence of certain readily identifiable events. He has just been granted bail.
Yes.
He has this morning been released from prison, etc. And is your point that here, Mr. Justice Ritchie is sliding from that sort of hard and fast compliance with a protocol to evaluation of individual circumstances in an individual case to see whether they might in some way be regarded as analogous to one of the code of practice duties?
my lord, yes, but he's gone further than that to declare it as an absolute practice that would arise
Yes.
in such circumstances.
Yeah.
Okay. But in any event, it would have been for the claimant to have demonstrated breaches of those duties. And in fact, the evidence was that the officers had fully complied with that national guidance.
What he appears to be saying, paragraph 115, this is as it were, an organisational failure of the police. And implicit in that is that perhaps they haven't appropriately instructed the call handlers to add that to their list, as it were, of matters that you have to inform somebody who may be in potential danger about. That appears to be one of the ways in which certainly 115 could be interpreted.
Yeah.
Seems to me.
Can I just, I'm sorry to niggle away at this, but I asked you about the position if the duty as found was specifically a duty to warn about a message such as was given to the police. And I'm just looking again at 114 and 115. 114 is the end of his consideration of an analysis and conclusion section. And he says that the judge was wrong to reflect the pleaded case that the defendant owed a civil law duty to warn her on the facts of this case. And 5 lines from the bottom of that page, I have already found above that a duty of care to warn by phone existed.
Yes, my lord.
What he, and as I read it at the moment, but please tell me if I'm wrong, that is the premise on which the whole of 115 is based.
Yes, my lord. He's found a specific duty in this case that would require a phone call to be made.
So while you may want to guard against us going off track, as you would see it, and finding some wider duty and some wider form of breach, if we find that the judge's conclusion that there was a duty to warn her on the facts of this case, if we find that that is not justified, your submissions become rather short, don't they?
Yes, my lord.
Okay.
And equally so, if there was such a duty, he was inevitably going to find it was a breach.
Yes, my lord. Which makes my submissions equally short.
I'm sorry, I didn't hear that last one.
Sorry, no, if there was a duty to warn, there was inevitably a breach.
A breach, yeah.
Having found all avenues to short submissions on breach.
But just before you move to anything else, is Mr. Justice Ritchie saying in 115 that it's an absolute duty or a duty to take reasonable care?
Well, I think my lord's point is that he's finding at 114 on the specific facts of this case, it's an absolute duty.
So if she happened to be solidly engaged on the phone to someone else, up to and including the moment of the attack, it would be a breach of the duty.
Well, no, that would be the duty would have been complied with by the fact of the making of the call.
Well, civil law duty to warn her?
Well, I suppose, yes, on the basis that the phone call didn't connect.
All right, okay. Anyway, a very specific duty.
My lords, in relation to causation, again, Mr. Justice Ritchie's submissions and findings flow immediately after the paragraphs that we were just considering. He doesn't appear to have found that His Honour Judge Murdoch was wrong in the findings in relation to causation. I say that because at page 91, paragraph 120 of Mr. Justice Ritchie's statement, just judgment. He says this, whilst I was minded to make such an inference, it seems to me in these circumstances there is no scope for this court to declare that the judge's decision that there was no evidence upon which he could make a finding that any breach by the defendant caused the loss was wrong. So, to the extent that the appeal might have been brought on Civil Procedure Rule 52.21.3a, that doesn't appear to be the case.
Where were you?
In the middle of paragraph 120, my lord.
Thank you.
So that, by inference, is why he has gone on to rely, as it must be, upon Civil Procedure Rule 52.21.3b, that the appeal court will allow an appeal where the decision of the lower court was unjust because of a serious procedural or other regularity in the proceedings. The difficulty is that no such procedural or other irregularity has been identified, and certainly not a serious one, either by Mr. Justice Ritchie or by the respondents to the appeal. to the extent it said that there was a misunderstanding about causation being an issue, all parties before His Honour Judge Murdoch proceeded on the basis that causation was an issue. And again, I don't think that is a matter that is disputed by the respondent. So again, that being the case, I hope my submissions on causation can be equally short.
Well, they might be a little bit longer because I've got a little question for you. Can you go to paragraph 33 of Tyndall in the Supreme Court?
Yes, ma'am.
Which is a passage from Capital and Counties, paragraph 131, page 1034, paragraph 33 of Tyndall in the Supreme Court.
Yes, my lord.
How does this work? If you lose at every point down to this point, there's a duty, there's a breach, and prima facie there's the possibility of damage. The reliable Lord Justice Stuart-Smith said, in such circumstances the defendant would at least prima facie be liable for the extra damage unless they could show, and the burden would be upon them, that the damage would have occurred in any event, even if they'd never come upon the scene. If they were unable to discharge that burden, they would be liable. How does that work?
Well, my lord, it's a fundamental part of the claimant respondent's case that the damage was going to occur and that the appellant defendant's failure was failing to prevent that damage occurring. So the extent of the damage to be caused was always going to be the same and was always going to originate from the same source. In this case, what had happened is that the plaintiff had taken steps to limit the extent of the damage, and then the defendant's negligent act had removed that protection, and that further damage had been then caused, and therefore the extent of the damage attributable to the defendant's act had to be shown. But that isn't this case.
Why was it inevitably going to happen?
Well, if the attack wasn't stopped, the form and the extent of the attack was always going to be determined by the acts of the third party.
No, I mean, if presupposing there was a duty to warn and there was a breach and it was going to be acted upon, in other words, the warning would have been acted upon, are you still saying that, there would have been, the damage would have occurred?
Well, that brings in the next question of whether or not the claimant respondent would have heeded the warning and stayed in the house.
Yeah.
And the difficulty there is you've seen His Honour Judge Murdoch's findings in relation to that matter. You may not have seen or appreciated that in fact the claimant wasn't, or claimant respondent wasn't answering her phone, because of course there had been a call from the appellant to the claimant that had gone to voicemail. And again, that is in the transcripts, supplemental bundle, page 89. So there would be issues on causation there in any event. The phone call in the supplemental bundle at page 89, and it's unhelpfully untimed, it's track 11. So you get the almost universal voicemail announcement, and then from the operator, hello, this is a message from Mrs. Woodcock, it's Northampton Police again, can you call back as a matter of urgency please on 101 and quote your incident number 7, thank you. So there's 2 points on causation to be made from that. The first is a phone call has been made and not answered.
And when was that?
I beg my pardon, my lord.
When did in the chronology? When? Did
Well, the calls are arranged in chronological order, but they're untimed. But it's the last call before the call from the neighbour. But the second important point to be made from the voicemail call is one thing to miss a call and not to answer it, but then there's the further evidence that the voicemail that has been left has not been accessed, or if it has, it hasn't been actioned.
I'm sorry, I'm finding this difficult. Track 11,
Track 11.
we don't know the time for.
We don't know the time, but we
Do
do
we know the date? I'm just looking at track 10, where those with detailed knowledge of the facts of the case may be able to put a date on this.
That's sometime on the 18th or early on the 19th.
Track 10 is 10 minutes after the police have taken a statement from her and have just gone.
So this is where he's come back and then the police reattend
Yes.
in the early hours.
Right, so that's several hours earlier. So track 11, we can say, can we, it's into the relevant date, but whether it's in the early hours or
It will
hot
be,
7-ish, it's hard to say.
it's impossible to say, but what you can, and what the evidence was, because they're arranged in chronological order, you can say it's after the last time that the claimant respondent telephoned the police.
Yes.
So it's after the last attendance by the police officers. And it's before the neighbour calls. And the point that I make on the facts is 2 points to be inferred. First of all, the call was not answered. So the failure to warn would not have been successful, or had that been the call.
But hang on. Track 12 is the neighbour.
Track 12 is the neighbour, my lord.
So the warning hasn't been received.
The
at
warning
time
has
of
not been received.
So what's that got to do with not passing on the warning?
The point I'm making, my lord, is that the breaking causation, if there were an obligation upon the appellant to make the call, the claimant would have to show, first of all, that that call would have been answered. And secondly, that if it hadn't been answered, she then would have checked the voicemail, which she hasn't done. And this is perhaps sidelined, but arises from what my what I said about the findings of His Honour Judge Murdoch in relation to the claimant's attitude and independence and unwillingness to be cowed.
Well, I see the point, Mr. Holcroft, but you perhaps have to be a bit careful, because since all we can say is that it's after events in the early hours,
Yes.
and before an event around 7:30, there may be thought to be a difference between your phone not being switched on at 4 a.m. and your phone not being switched on at 7:15 a.m.
Yes, my lord.
And this wasn't investigated at trial.
There was no evidence as to what the time. There was no evidence as to what the times of the individual calls were, my lord.
But as I understand, there's no specific evidence going to whether or not the claimant would have answered between 7:30 and 7:45.
No, my lord.
I'm still troubled by I'm still troubled by this. And it's forgive me for just returning to it once more. He's using the analogy of East Suffolk. Suppose that the defendants came upon the land to repair the main wall and negligently destroyed the temporary wall. Suppose the police came and there was a duty and they removed a level of protection. Just to suppose. So the area of the flooding increased before the repairs were completed. So she was less protected than she would otherwise have been. In such circumstances, the defendants would at least prima facie be liable for extra damage unless they could show, and the burden would be upon them, that the damage would have occurred, which in this case is the wounding and the attack, would have occurred in any event. So on that, if that's the right way to approach it, I'm not suggesting it makes it right to remit it to the county court. But it does mean that the burden, which clearly wasn't discharged because I don't think it was addressed, was on your side to disprove causation rather than in a more conventional way for the claimant to prove causation.
Well, my lord, I don't think my lord is correct, because my lord has changed from the two forms of damage. So when my lord started, my lord referred to the less protected as being the damage caused by being
The risk created
the risk created.
by the absence of a protective shield, however you like to put it.
But that's a different damage to the actual damage, because that doesn't manifest itself in any way. And that would be a consideration of the existence of a duty stage, because you're trying to quantify the extent to which and the extent of that duty, as opposed to what the damage caused by a breach of that duty might be. Whereas this extract is focused entirely upon the damage in the true sense, as opposed to the extent of protection that may or may not have been provided. So,
But all of this could have been avoided by about 3 questions at trial. Miss Woodcock's counsel to Miss Woodcock, what would you have done if you got the message? And she'd either have said, I'd have gone out anyway, or she'd have said, I would have stayed in my house until I knew I was safe. End of. Because any judge is going to accept it one way or the other. Because there's no suggestion she's
yes, my lord. And again, this was raised by His Honour Judge Murdoch before closing speeches commenced.
Well, that goes to remitting and so on and so forth. But if we're satisfied that we've got to look at it as it was before Judge Murdoch, that he didn't err, then we've just got to work out what page 1034 of Captain and Counties means, if it means anything in this context.
Well, I suppose if you were trying to move that to an analogous position, you would run with the bodyguards scenario, and you would talk about an incident where there was a person known to be at risk of harm who'd chosen to have 3 bodyguards stand by. Then the police arrive and say, you don't need all 3 bodyguards, so we're going to remove 2 of them and station 1 officer there. And then the attack happens in the form of a Range Rover being driven through the house and collides with the person in the living room. So in that situation, I can see that the burden might have fallen onto the defendant to say, well, the damage would have been the same in any event. But I think the trap that my lord is falling into is describing the change to the risk as a form of damage.
Well, it may be difficult to compare and contrast the factual circumstances, but in the passage cited, there is a small flooded area.
Yes.
And if everything stays as it is, the area of flooding is not going to get any bigger.
Yes.
Eventually it will get smaller because everything will be mended, but it's not going to get any bigger. As a result of the negligence, it does get bigger. I think you made the point a few minutes ago that here, your submission is, it's the claimant's own case that unless RG was apprehended or otherwise prevented, he was determined to carry out his attack.
Yes.
So the attack was going to happen unless and until he was stopped.
Yes, Mark.
Okay. Well, I think I understand the distinction you're drawing. Okay. Well, several minutes ago you thought you'd finished, and I'm afraid we've pushed and pulled you in all directions. All right. Thank you very much. Anything else? No. Thank you. Good. Now, how are we doing then in the overall scale of things?
Well, I think we're okay because my learned friend told me earlier to take as long as I needed. So I'm assuming that means we're all right for today.
Right. But you've now effectively finished at this stage of your submission. Yes.
I assume you don't want me to start now.
It's a shrewd assumption. Thank you all very much. We'll sit then at 10:30 tomorrow. Our thanks to everyone for their help today.